If a creditor seeks an earnings garnishment from you based upon a judgment, there are legal remedies that may help you avoid that garnishment. Well, what are those remedies? That's the topic of this video. Hello again, everyone. I'm attorney Robert Flessis. If you're new to this channel, now is the best time to subscribe, because if you do subscribe, you'll know where to go to get answers to your legal questions. When a creditor obtains a judgment against you for a debt you owe, that opens the door to the creditor going after your wages. If you're employed, the creditor's attorney goes through a simple legal task to clear the way for an earnings garnishment. Garnishments can include not only the amount you owe, but statutory interest and costs. But the creditor first needs to obtain a court order to garnish. If they get that order, then they serve notice to you and your employer for the garnishment of your wages. Once you receive those papers, you have the right to answer, provide a possible defense, and have a hearing in court before the garnishment proceeds. If you fail to answer the filing of a garnishment, then the garnishment proceeds, usually on your next payday. Every state has different rules for the amount that can be garnished from your earnings. In the state where I practice, for example, 20% of net income can be garnished, and only one creditor can garnish you at a time. There are defenses to a garnishment, but you have to argue any defense to the court before the garnishment begins. Check your state law to determine how much can be garnished from your paycheck. Your state law may provide you with defenses as well, but you have to check. Federal law provides the protection. If your total household income is less than that of the federal poverty level, then your wages may be protected from garnishment. But any amount above the poverty level can be garnished. If you're receiving or approved for public assistance within 6 months prior to the garnishment action, then you're automatically protected from garnishment. If none of this applies to you and you're not protected, then bankruptcy may be an option for you. You can get the debt discharged under a Chapter 7 bankruptcy, or if you don't qualify for a Chapter 7, you can seek relief under a Chapter 13 debt repayment plan. Another solution would be to try and obtain a monthly payment plan with a creditor to avoid a garnishment. Many times creditors will allow that, but you have to make the payments each month. If you don't, the creditor will garnish your wages. The bottom line here is that once a judgment is obtained against you and you're employed, you need to pay attention if you're served with garnishment papers. I'm attorney Robert Flessis. Remember to subscribe, like, and share. Thanks for watching, and I'll see you in my next video.